Very good afternoon to all our online webinar. I hesitate to call it a community because a community means we are dedicated and know each other, but loosely used a webinar online, there is a sense of community. Our networking here is a beginning of a relationship of stakeholders, lawyers, engineers, construction law specialists, even some business people I saw may be interested on this whole area of contract law. In our Saturday, we had a good opening by Young Arif, Datuk Mary Lim, and her speech will be, we hope, published soon, and we will send copies to all participants, and also Dean Johan. On behalf of the University of Malaya, Faculty of Law, this initiative has been one which the university, as the Dean reminded us in his speech, as the academic institution would have that objective of relationship with the private sector and with the real business world in issues arising from contractual transactions, construction, engineering. We all know the core, as both of the speakers in the opening address, of commercial life is contract law. Therefore, whatever we discuss, there is an interrelationship. Although the topic is in a kind of focused manner, we all see that each of the topic has a relationship with the core of contract law principles. And in 21st century, we can see that towards the late part of 20th century, contract law has given rise, both juristically and judicial decisions, to a fruitful evolution in all of the Anglo-American and what we call common law countries. This afternoon, we are grateful. We have two topics of vital interest for all of us. One of them deal with, we will have soon, the issue of liquidated damages. We have shifted the program somewhat because to accommodate the fact that the capacity team on the minority would like to be after the session, that means later. So today we will move the LAD session up, and I will hand over now the moderating of this session to my respected colleague in law, who gave us also one of the keynote address on Saturday, but he himself has a vital interest in this whole area of liquidated damages, Section 75, Malaysian Contract Act, and issues arising judicially or otherwise in this area. I give you Mr. Un Chi King, a senior Malaysian practitioner of the Malaysian Bar, much involved in contract law issues and dispute. Mr. Un, over to you.
Thank you, Prof. Philip. Now, we all know liquidated damages clause can be found in almost all contracts. Contracts, for example, construction contracts, contract for the sales of houses, shares, etc. However, the law in this area, in this what properly called a vital area, an area of vital importance, is governed by our Section 75. And the interpretation of this Section 75 cannot be said to be free from controversy. Partly, maybe I can say that, is because of convoluted drafting of Section 75 itself, which does not lend itself readily to easy interpretation. For this, it's unfortunate, bearing in mind this uncertainty in the state of the law, bearing in mind the fact that, for example, in construction contracts, this area is still not free from any certainty. And the law governing this area, as laid down in the famous case for more than a century, the case of Dunlop pneumatic tire, has recently also has undergone massive changes, radical changes from where it was first pronounced, i.e. in England. About 100 years later, or slightly more than 100 years later, the cases of Cavendish, Parking Eye, the co-joint appeal of these two cases, has in a way reformatted the law in this area. And in Australia, Andrews, Picasso, and in Singapore, Denker has refused to follow Cavendish. And right here in Malaysia, the latest case of note is of course Cubic Electronics, for which the speaker which we have today will have more to say. So with this state of the law in a state of flux, if I can call it, where are we heading to? Can we reconcile all the different cases? Now we are fortunate today to have Ms. Chung Sao Mei to speak to us today. Now Ms. Chung has had a very varied career. She was a practicing advocate and solicitor. She is an academic, and she was also an in-house counsel and was formerly the head of legal department in Maybank. So coming from this varied background, I'm sure we have much to learn from her and to see what she has to say. So over to you, Ms. Chung, for your presentation. Thank you.
Thank you, Mr. Un, for your kind and generous introduction. Good afternoon, Prof. Philip, Prof. Zura, Deputy Dean of the Law Faculty, Prof. Cheong, and other esteemed presenters and moderators, esteemed colleagues, ladies and gentlemen. It is really a privilege to come and speak to you about, I would say, one of the cases which I consider to be a landmark case in Malaysia. And let me share my screen now. Well, I've titled the topic as position of LED clauses under contract law. Sorry, I don't know why it has moved. Sorry, let me redo that again. I'm not sure why it has jumped to. Right. Position of contract law, LED clauses under the Contract Act 1950, and I've subtitled it as Keeping in Step with Commercial Reality. I hope by the end of this short session, you understand why I say that. Right. Well, LED clauses, as Mr. Un has pointed out to us, they are very important in the commercial sector. What are they? They are an amount the parties have agreed upon during the formation of the contract as compensation upon a specific breach which the injured party is entitled to collect. I say that normally, often negotiated and agreed upon by both parties, although we know, of course, there are some clauses that are imposed and maybe therefore subject to scrutiny by the court. I want to highlight how this LED clause allow parties to allocate their risk in their contractual dealings. They are meant to avoid lengthy and expensive litigation, and above all, they provide for certainty, which is something that we would appreciate. Now, law on LED clauses, as Mr. also mentioned, is found in the 1915 case of Gunlock Pneumatic. The most important feature of an LED clause is that it allows the party to claim the amount without having to prove damage, provided it is a genuine pre-estimate loss. That was in Now, in 2015, Cavendish Square Holdings and Masaksi, the UK Supreme Court reformulated the test as looking at a secondary obligation to see whether the amount imposed is out of proportion to any legitimate interest of the innocent party. Now, I will be discussing this in length, so I just wanted to highlight that there was, in 100 years, there was a reformulating of the test. I would like to point out that in Malaysia, LAD clauses are considered important. I have chosen a dicta from Young Ahmad Arif Muhammad Dawawi in the case of Malaysian Cement, where he pointed out that a liquidated damages clause permit parties to enter into contractual relationship with a better understanding of their respective rights and obligations, and that it eliminates cost and delay of a complex loss and profit analysis. Well and good. In fact, I would also like to point out to a very recent case in the UK. I have given talks on Triple Point Technology Inc. and PTT Company Limited when it was decided by the Court of Appeal. The UK Supreme Court did not agree with the Court of Appeal desire to depart for what they call the orthodox analysis of allowing LAD for delay, even in cases where it wasn't delay, but it was a termination. In departing, in refusing to adopt the Court of Appeal decision, the Lady Arden of the UK Supreme Court has this to say. She talked about the suggestion by the Court of Appeal, the decision, as being inconsistent with commercial reality and the accepted fundamental of liquidated damages. And she also said that liquidated damage is a remedy that's predictable and certain, and therefore the party enforcing it does not have to quantify loss, which is difficult and time consuming. So this was delivered in 2021. I personally do not find the UK Supreme Court decision satisfactory compared to the argument by the Court of Appeal given by Sir Rupert Jackson in the very careful analysis. But I can understand the Supreme Court concern about departing from standard practice. Now, so what is Section 75 about? This is the provision. I will not take the time to read it. I'm sure all of you are familiar with this, but I will just highlight to you what are the judicial issues arising from this. Well, it says that the issues are, the law is said to declare all LAD clauses to be penalty. There are many cases on this point, and I think it's not an issue that. The second question is whether or not actual damage must be proven, because the clause has a provision that says that whether or not actual damage or loss will be proven, the party is entitled to receive reasonable compensation. Reasonable compensation is the other term being raised in judicial interpretation. And the final concern is whether the court can go beyond the amount that's stated in the clause itself. Now, sometime in the early 1990s, where there was this uncertainty in the law about the position of liquidated damages, there was an article by now Mr. Justice Lim Chong Fong, where he looking at the chaos regarding LAD clauses, submitted that the real difference between the English position and Section 75 lies in only one minor position, which is if the law is declaratory that any superior sum is a penalty, then the onus is on the party seeking to enforce the provision to establish that it is a genuine estimate. That means the party suffering the default. Whereas under English law, it is the party who is challenging the enforcement of the clause. Now, I call it a prophetic voice. Maybe it was a voice in the wilderness, because 2 years from then was the case of Selva Kumar. Now, Selva Kumar was decided in 1995, where the federal court held that, I would say it was a genuine attempt by the federal court to interpret what is a problematic provision in Section 75. Nevertheless, the federal court came to the decision that damages must be proven. And I will not be reading the slide. I will leave it to be sent to you. So in Sabah Kumar, the federal court decided that in Malaysia, all LAD clauses are penalty and therefore unenforceable, save for a small number of cases. Some, I think, was called the first class of cases where no known measure of damages is employable. Yeah, it says, right, where the court find it difficult to accept damages for actual damages that are employable and yet clearly shows some real loss inherently, which is not too yeah. So that is the position in Sabah Kumar, okay, where it's not too remote. Now this ruling in 1995, to me, seriously undermined the importance and effectiveness of LAD clauses. And I'm always, in explaining to my students, I am always find it a challenge to explain why LAD clauses is, I mean, these are clauses agreed by the parties. They are meant to have serious commercial implication and values. But are we to say that in Malaysia, say for the small number of cases, LAD clauses will not be enforceable? So what happened, sorry, let me just, before I go. So what happened after Sabah Kumar was, they were High Court decisions that either ignore Sabah Kumar. There was the case of Sakinas, where Justice Abdul Aziz brought the LAD clause in a statutory SPA within this limited number of cohort of cases where there's no known measure employable. Mr. Justice Malik Ishak, in another case of Yu Kiong, talked about parties who would put in their clauses that this is a genuine estimate, and also numerous efforts were made to navigate the difficulty imposed by Sabah Kumar. And it was not until 2009, in the case of Johor Coastal, where the court had relooked at this. In fact, I must mention in 2006, the federal court, in the case of Metromac and Faculty Corporation Holdings, did discuss and considered the LAD clause in that case, referred to the penalty test in Danube Pneumatic in the light of Section 75, and said that Danube Pneumatic is applicable in Malaysia, but found the clause to be a penalty. So, but no mention, no reference made to Sabah Kumar. So in Johor Coastal, the question was posed to the federal court, that part, whether that part of the decision in Sabah Kumar, which obliged the party with the benefit of the LAD clause to prove actual loss, was correct. And the federal court said, yes, it is correct. They did not answer the question whether the parties were entitled to contract out the provision, saying that it wasn't necessary based on the facts of the case. So this, of course, tied the hands of the court even more and put the commercial parties in a very difficult position. And I would highlight especially those in the construction industry, where LAD clauses is part and parcel of their contract. Now, let us not think that Johor Coastal was a unanimous decision. There was a dissenting voice, and Ms. Yang Arif Hashim Yusof actually had pointed out, although proof of loss and damages can be given, not that they can't, it would be a very lengthy process. But the parties agreed, that's why parties agreed on the stipulated clause for breach. And his lordship did refer to let me now show you a clause in an effort to avoid the effect of Sabah Kumar ruling. You can call it, I suppose, contracting or Section 75. This is clause 22.2 of the PAM contract 2018, and the similar clauses even in the earlier version of the contract, whereby it is stated the liquidated damages stated in the appendix is a genuine pre-estimate of loss and or damage. And it says that the employer, the parties agreed to pay, the employer, the contractor should agree to pay without need for the employer to prove his loss and damage. This is just one of the many efforts by parties in drafting their LAD clause to bypass the implication of seva coma. Now, I'm going to point out now that in qubit electronics, there was a arbiter, only by the arbiter, that parties may not be at liberty to contract out Section 75. Now, so we have a scenario where LED clauses are useful and important. We have a scenario where the kind of parties are tied further because of the coma then affirmed by the poster. Now, in 2017 to 18, just before qubit electronics was decided, in my research, I found there were 4 cases, including qubit electronics, that was decided and heard before the Court of Appeal. And I highlighted for you the cases on the slide. And they are not small contracts. They are not, but a contract between parties of standing, equal standing, like Malaysian Cement, the contract to purchase iron ore. There was a construction contract in state construction. The Good National, which have been settled recently by the federal court, it was a huge contract to develop entire core system for infrastructure on repayment facilities. And of course, there was qubit electronic and mass calculation, a 90 million contract. So here we have this, and the Court of Appeal had nevertheless I put it in the words of our current Chief Judge. It says that it is settled, and these cases come to the conclusion, it is settled law that if a sum is named in the contract to be paid, in the case of a breach, it is to be treated as a penalty and therefore void under Section 75 of the Contract Act. So Arif, this is a statement by Arif Maimun in the case of State Construction. No, sorry, in the case of Tengku National. So you see, there were 4 matters, 4 cases on contracts with LED clauses heard by the Court of Appeal, all were, in spite of what Yang Marish, Muhammad Nawawi say about the importance of LED clauses, but because of Section 75, because of Sabah Kumar and Johor Coastal, the clauses were held to be void, unenforceable. So to me, when qubit electronics went up to the federal court, it was quite inevitable that the matter had to be reviewed, and so they did. Now, qubit electronics is a standard sale purchase agreement of plant and machinery in the amount of 90 million, and there was a 1 million under deposit paid, and the parties were supposed to sign a sale and purchase agreement within a month, whereby a 10% deposit would be payable. But there was numerous delay on the part of the plaintiff. So further extension were granted, three extensions, I think. By the 4th extension, when the party fell out, the sum of 3 million has been paid, and some other 40,000 for non-refundable interest. At this point in time, the plaintiff then took the defendant, the vendor forfeited the 3 million, and the purchaser plaintiff sued for the return of the money, and using Section 75 of the Contract Act. And what is interesting actually is, in terms of deciding on what amount to deposit, you can see the different treatment given by the High Court and then the Court of Appeal. The High Court says that the sum of 3 million, not 1 million, 3 million are true deposit, whereby defendant did not prove loss, right? When it came to the Court of Appeal said the sum of 1 million is the true deposit, and then they dealt with the balance of the 2 million using Section 75. Kumar saying that the defendant has failed to prove actual loss, therefore they were not entitled to forfeit the amount. This matter then went to the federal court, and now the federal court decision, I have set out the entire decision because it was a restatement of the law, so it was set out extensively in the judgment. I will leave it to you for you to read it. I just want to highlight some of I'll be discussing the decision length. So like Roman para 3 deficit section 25 is one of the key principle, and then Roman item 4 in determining what amount of reasonable compensation, the court used the concept of legitimate interest and proportionality as was propounded by the UK Supreme Court case of Cavendish. And so I will be discussing this at length. So this is just the list of the restatement that was set out by Yama Arif Richard Malanjum, the Chief Judge of Sabah and Sarawak as he then was. Now why is the federal court discussing LAD cases, the LAD clauses, when the case in fact deal with deficit? I personally consider it to be quite a admirable attempt by the federal court, no doubt dealing with the case of deficit, to, because of the development in the UK, use it as a springboard to re-look at the position of LAD clauses in Malaysia, which was giving much grief to the stakeholders at large, right? Because remember, there were these 4 cases that were heard before the Court of Appeal. So Cavendish, in deciding that the law and penalty is still viable, went on to discuss about how the law and penalty and the law and forfeiture were being aligned, and in the process, in looking at deficit, one should apply the law and penalty using legitimate interest and proportionality to consider whether a deficit should be forfeited. So it looks as though there's now this alignment of 2 rules of 2 principles, but although both may have originated from equity, but were traveling in parallel, but they were not. Yeah. Now, based on this alignment of the law and penalty and law against forfeiture, the Federal High Court adopted the development and say now Section 75 applies to deficit, which is a departure from Mingi Plantation, decided many years earlier. But more importantly, the learned judge went on to talk about LAD, but I don't think I need to discuss one of the issue about the reformulated penalty test. It is said to apply to secondary obligation. That means provision regarding damages. So in the case of Cavendish, in fact, when it came to the actual judgment, the learned court held that the 2 clauses in Cavendish, which I just briefly mentioned now, before I go on to what is relevant to us, these 2 clauses, 5.1, 5.6, where Mr. Madexi will receive a smaller sum, will not get his goodwill, are merely price adjustment clauses, and they are therefore primary obligation. Not so the penalty test is not relevant. I just want to highlight that. But so what the Supreme Court decided was, yes, the penalty rule is irrelevant, though not applicable in Cavendish, and it regulates primary, not secondary, also secondary, not primary obligation. And most importantly, in the it applies equally to obligation to transfer asset or clauses where one party forfeits deficit. So this is what we have discussed already. Now, and it broadened, most importantly, it broadened the test in Dunlop Pneumatic. I would not say it did away with, not at all. It just broadened, and so by introducing this concept of legitimate interest, I think the concept of proportionality is not so different from what Dunlop Pneumatic had in mind. But the concept of proportionality is very interesting in the sense that they feel that in modern contract law, just the mere concept of deterrence and genuine perception may not be that helpful, right? So they're looking at, because in some cases it will appear that there may not be actual loss threatened, but there might be a legitimate interest in imposing a sum payable for breach. Let me, so I will not look at that. And this was clearly identified, applied in the case of Parking Eye Limited and Lewis. Now, Parking Eye Limited and Lewis was heard together with Cavendish. And this is a small case, actually. It just involved Mr. Bibi parking in a retail car park where there's free parking for 2 hours. Mr. Bibi overstayed the limit. He was imposed, and there was a £85 charge imposed. And Mr. Bibi challenged that imposition of that penalty, so to speak. And now, what is interesting is how the concept of legitimate interest was applied. Obviously, if the parking is for free, it is possible that there was no loss, no specific loss incurred, no pre-estimate by parking right. So, but the court held that because they are managing the car park to facilitate availability of parking for the retail shops visitors, there was a legitimate interest to impose such a charge, even though no actual loss was foreseeable. So I just want to highlight this as an example of this concept of legitimate interest, which is actually very interesting because it may be something modern businesses may require. Anyway, in this case, the charge of £85 sterling was held to be not extravagant and unconscionable, simply because the British Parking Association has set a limit of £100 in such cases. This is what I normally refer to as the industry standard. Sometimes to decide whether something is extravagant or unconscionable, we refer to the industry standard. Now, how was this test applied to cubic electronics? Well, in the court, in most contracts where parties are business in the business setup, it will not be difficult to find legitimate interest, unlike the case of parking and bills. Nevertheless, the federal court did analyze and say that the defendant holding on to waiting for the plaintiff to execute the sale and purchase agreement, was deprived of a chance to enter in negotiation with other parties, and to secure to avoid further delay. All these are legitimate interests to impose the LAD clause. So that is how they discuss it. As to whether the amount is disproportionate, unreasonable, and so forth, the court said that the 2 million plus the 1 million that was going to be forfeited was only 3.3% of the purchase price. Therefore, the industry standard for sale and purchase agreement being 10%, this was not disproportionate or unreasonable. And of course, they went on to explain that to hold that the plaintiff failed to. The plaintiff in this case, and this is one of the issues that failed to show that it was excessive. Therefore, the clause was enforceable and the amount forfeitable. Now, what is the impact of cubic electronic on the Sarvakumar ruling? Well, I would like to say that clearly, in terms of the requirement based on the word whether or not actual loss is proven, the courts now say that once the LAD clause, there's an LAD clause in the agreement, the innocent party can enforce the state clause without having to prove actual loss, subject to the clause being challenged as a penalty. Now, what this to me directly contradicts the ruling of Sarvakumar. But what happened was the federal court did not, in effect, overrule Sarvakumar. They have said Sarvakumar, the requirement to prove actual damage may be a starting point in challenging the penalty clause. Now, some of the issue, remember the judicial issue that were raised, meaning of reasonable compensation. So that's another. Well, the court has now, the federal court now fully accept the concept of legitimate interest and proportionality in deciding what is reasonable. And to me, reasonable is not something that the court needs to decide based on evidence as much as is the sum name in that clause reasonable or not. And other than industry standard, one of the way of the principle given out in is that to determine whether the sum is reasonable would depend on the amount stated compared with the highest conceivable loss in the event of breach. So that's how the parties. So if it is not proven to be excessive or exorbitant, then the amount is recoverable. Now, the only issue I have with the decision in Selva Kumar is the issue regarding burden of proof. The federal court has now decided that the burden of proof is on the defaulting party to prove that the clause is unreasonable. Because of earlier decisions saying that all Section 75 declare all stipulated sum to be a penalty, I feel that this may not be a principle that's consonant with the wording of Section 75. But that's not to say that it's wrong. It just doesn't fit with the wording, because I mean the counter argument would be, if the two parties have agreed to a amount, then the party who says excessive should normally be required to prove. It's just that our Section 75 has been interpreted as declaring all causes to be penalty first. Anyway, I would like to refer back to what Mr. Justice Lim Chong Fo has said earlier in 1993, and how in 2019, so yeah, sorry, there's an error there. 2019, he wrote about the decision in Cubic Electronics, and I just want to highlight one interesting point that he made, which is he has highlighted legitimate interest as possible means of assessing the relative bargaining position of the contracting party. That's not in the decision, as far as I can tell, but he is of the view the court will more readily uphold the stipulated provision if the parties have pre-negotiated the contract arm's length. And well, that may be an interesting way of looking at legitimate interest. And I leave that to see how it will be further developed. So to me, Cubic Electronics decision reinstated viability and importance of LAD clauses. Selva Kumar is severely limited, even though not overruled. There's now a clear and emphatic restatement on the law LAD, which to me was much needed and widely welcomed by the commercial sector. I do feel, of course, I'm aware that LAD clauses can be used to impose severe liability on the weaker party, but that is what the penalty rule is here to do. So to me, this is a commercially sensible approach. Some post-Cubic decision, most of the High Court and Court of Appeal have cited with approval, although may not have applied it. Yeah, and these are some of the cases that, yeah, by a diverse panel of judges. There are two cases that I just want to briefly highlight. McVilla, which is a Court of Appeal decision, McVilla and Marine Guan Yinghui. There's a judge, some quite serious criticism about how Cubic Electronics may have accepted on the wholesale acceptance of English law, contrary to the provision of the Contract Act. Recently, the Federal Court has decided in the case of Tactical National and Plentitude, remember, which was one of the 4 cases that was decided by the Court of Appeal at the same time as Cubic Electronics. The decision seemed to suggest that Selva Kumar has been overruled because the court was talking about issue of retrospective and prospective overruling. So can we take it that notwithstanding the reluctance of the federal court in Cubic Electronics, Selva Kumar has in fact been overruled? And is there a basis to, but what was rather troubling about the decision was that the court seemed to suggest that upon the failure of the party to prove that the LAD clause is enforceable, they seem to suggest that such a party should not subsequently be allowed to prove its actual loss by process of assessment of damages. Well, that is yet to be clearly commented upon. Now, I just want to close by referring to why is there a need for reform? Well, to me, Cubic Electronics was a sterling effort by the federal court to iron out the problematic legal position on LAD clauses due to Section 75. But in fact, it was more than that. It was also updating the penalty rule in line with modern commercial practices. There's now a clear restatement of law. Now, however, you can see that it was a challenging journey, and the critics are not out there. I don't suggest that there are no questions or issues raised by Bibi Electronics. I just want to show that it has reinstated what is something very commercially important. But I can understand that because of the wording in 75, the journey was most challenging, and I think all the stakeholders, whether it is the construction industry, people who are courts, judges, lawyers, were all having to navigate a problematic area of law because of the provision of Section 75. And maybe in light of this, I mean, this is the reason why we're even talking about reform. And I just want to say that unless something is come to fruition, I would like to make a clarion call for all stakeholders to keep in mind that when we decide, whether you decide or argue contract law principles, there's a need to keep in mind that any development must be in step with commercial reality. And on that note, I will end now. Thank you for your attention.
Thank you, Ms. Chung. Thank you, Ms. Chung. Well, before I invite questions from the participants, I have a few remarks and maybe observations. Section 75, there are a few key phrases. One is reasonable compensation. The other one is whether the loss of damage is proved to have been caused thereby. Now, firstly, reasonable compensation. Well, to prove the reasonableness or otherwise of compensation, if there's no evidence having been adduced, how can this reasonableness be proven? That's point number one. Point number two, right? Just now there's some talk, okay, I think in by reference to Justice Lim Chong Fong's paper of the freedom of contract. And I think a big reference to it was also made by Justice Wawi in his Court of Appeals judgment. Now the question is, isn't Section 75 itself is a legislative policy on the intrusion to the party freedom to contract? And furthermore, right, as you have rightly pointed out, Justice Malangjun in Cubic Electronics has arbiter say that you can't contract out of Section 35. And Justice Lee Swee Seng in one of his first instance decisions has also said likewise, you can't contract out of Section 75, irrespective of the Citibank case, which everybody quotes, okay, when they say it can be contracted out. So that point, right? Firstly, the concept of reasonable compensation and the phrase of, for example, whether actual loss of damage is said to be caused thereby. These two phrases, are they contradictory? It's irreconcilable in the first place. And number two, to talk about bringing the law up to date and to uphold freedom of contract and party autonomy, so to speak, isn't the very objective itself of Section 75, as I queried just now, an intrusion into party autonomy. In fact, in Cavendish itself, counsel has invited the Supreme Court to abolish the penalty doctrine altogether, and this invitation was declined by the Supreme Court, thereby also maintaining that some degree of judicial control is necessary. The other thing I've observed is the Cavendish case is heard together with Parking Eyes case. One case involved, I think if my memory serves me right, is about 90 billion pounds. Parking Eyes case, right, okay, is only involved about 85 pounds. One is a consumer contract. The other one is a big commercial and business contract. Does that suggest that, at least in England, the law with respect to LAD and penalty are the same? Whereas in Malaysia, right, for example, Sakinas, by making what I call a loophole in Sabakuma, have escaped that liability. And Ms. Chung.
Yes. Let me respond. Yes, I think the issue about not being able to contract on Section 75 was explained in Cubic Electronics as this being a provision that was meant to protect a weaker party. So it doesn't conflict with the Citibank case. Yes, certainly I agree that the penalty rule itself is an intrusion into the freedom of contract. And I think again, it was also explained in, explained in civil electronics, a necessary intrusion, but limited in its extent. Because obviously, clauses are important and they are useful, but they can be oppressive at times. So hence the penalty rule. The only question is, because UK have got a lot of provisions protecting the bigger party, which we at this point we do not have, except for consumer contract. I could understand why Section 75 could reverse the burden of proof on the party seeking to enforce. I thought that was quite deliberate, but of course the interpretation is now different. So I agree that it is a necessary intrusion, but that doesn't mean that, but you have to look at the clause rather than to say that all LD clauses are void and unenforceable because Section 75. That to me was very drastic.
Charmy, could I add a comment here?
Yes,
Mr. Woon, thank you for your quick comments. I see a number of interesting chat questions, and of course we can't address all of them. But I thought I want to just make a brief remark. The phrase, whether or not actual damage or loss is proved, I think has misled a lot of people, my own humble view. That doesn't mean that no evidence need to be addressed. And I have not actually read the exact ruling of Justice Richard Malanjum, but I think there is a difference between the burden of proving, all right, which always result on the party having to assert a matter, and the onus of adducing some evidential facts so as to satisfy the fact that, and Mr. Woon, I borrow your very acute observation, there is a reasonable compensation despite the stipulated sum, all right? So this Section 75 comes from 1872 Indian Contracts Act. This is precisely what we're looking at. In 1915, you have Dunlop case that talk about genuine pre-estimate of loss. Now, when you look at it juristically, judges would like to still exercise some constraint, despite the fact that in one of the Indian decisions, they think that Section 75 cuts the Gordian knot between pre-estimate loss and penalty. There is still this sphere of judicial discretion as to whether something is reasonable compensation. And even Section 75, if I may respectfully submit, the illustrations itself, although Mr. Woon has ably highlighted in his first lecture on Saturday, all right, it's quite interesting. Illustration A, illustration F, which I can't read now. I invite lawyers with access to the Act to look at it. And G, so words like penalty and compensation is also still used in the illustration. So what we have is not simpliciter, somehow 75 completely able to deal with all the problems, all right? You still need a fact that judges will still look at a clause, though you need not actually prove actual damage, but if you have been disproportionate, if it is in the form of a kind of a penalty in terrorem, though we don't want to go there, the court still exercise a residual jurisdiction to view whether or not your sum can be claimable. All right. I think language reach a limit, whether you call it legitimate interest, all right, or genuine pre-estimate of loss. Of course, Cavendish has given us a new angle, but Section 75, and this is where the objective of this conference shows that Section 75 itself, while very serviceable for a long time, has thrown up major issues when met with commercial contractual realism and developments of late 20th century and early 21st century. And the juristic heat that it generated, and Ms. Charmy has ably shown to us how even the attempt of Malanjum to try to clarify itself gave rise to a number of qualifications that some people have, that perhaps the learned justice, which of course we have no, it's not a personal comment, may have relied too much on English Cavendish. But then again, it is a pronouncement of the federal court, all right? I may have range in area which I'm not really an expert. I noticed Nazim has some interesting comment, but I also note that comment about contracting out. I think that those are red herrings, you know. I mean, to throw in language like contracting out is all red herring to my mind. It's not a matter of contracting out. It is a matter of construction of the stipulated sum, whether it falls within 75, and the judicial tests and constraints if it goes too disproportionate, where judges still have a duty to say that is disproportionate. That's my humble view. Thank you for listening.
Thank you, Prof. Philip. And I think Dr. Nasim also asked a question if there's a difference between liquidated damages and liquidated and ascertained damages. My humble view is I do not think there is such a distinction, and there's no difference. Both are caught by Section 75. And the contracting out, right? I think the law is quite settled. Clause 22.2 of PAM contract is an attempt to contract out of Section 75. And I do not think that will succeed. Now, can I invite Dr. Nasim to maybe elaborate on his views on this and maybe to give us some New Zealand perspective? Dr. Nasim?
No, Un, I wasn't prepared for this, but generally I want to say that your view about the difference between liquidated damages and liquidated ascertained damage is also the view Professor Philip Kapper from King's College had mentioned to me in 1990, as long ago as that. It's just a habit that I think in the PAM contract, for instance, we call it LAD, whereas I notice in the newer contracts, the more modern contracts, we just stick to consistent wording, liquidated damage, that's it. In fact, my view is that we should stop using LAD at all, because then people start arguing like what I've suggested. It could be an argument. Some desperate lawyer might want to say, oh, but it's different. It hasn't been ascertained. But effectively, I agree that it's the same thing. On the issue of contracting out is perhaps, sorry, Un, did you say that it's settled now that you cannot, it won't be effective, the PAM contract attempt?
From my latest cases, I know at least two cases, one in Bibi itself, where the learned former Chief Justice said that you can't contract out of Section 75. And Justice Lee Swee Sing has also in the High Court judgment said contracting out is a no-no. And that is despite the open-cited cases on contracting out, Citibank and we belong to this effect.
I think that's because depending on the purpose of the provision, right? If the provision like 75 to protect legal party, then I guess Boon Leong doesn't deal with that. I want to just address something that Mr. Tan have asked. Just now, Philip did highlight this thing about proving actual loss. I think the evidence for showing whether it's a penalty or not is different from showing whether the actual loss itself.
Correct.
And so this does serve, so you may call an expert to say, in such a case, this will be a loss. Or in other words, they could be market, what they call industry standard, where it is already normalized that this amount is usually quoted as what is expected to be the loss. I mean, statutory agreement, statutory sale and purchase agreement, Schedule G and H would be an example of that, 10% on a daily basis. So that you don't even need an expert to give evidence. Now I look at what Mr. Tan asked about market practice. But I guess in situation where there's no market industry standard, like whether it's 10% or it is, or 85, 100 pounds in then I think the principle as set out in Bibi Electronic is you will have to call some evidence to establish that this is the amount that was in the clause, and this is the highest conceivable loss that could arise from the breach. So you're not actually proving loss, you're just establishing the highest conceivable amount.
Right.
So I think that is well, it's a lesser burden, I guess. Yeah. And if you fail to show there's reasonable, then it's back to proving actual loss. Yeah, I'm not sure whether that explain.
But may I suggest,
Will ask questions.
that the learned Chief Justice, right, Justice Richard Malangjun himself, in his judgment in Cubic Electronics, has also muddied the water somewhat. For he himself say that evidence of the actual loss may be a good starting point. And that was what he said.
Yes, I do perceive a general reluctance to overrule Sagar Kumar and say that, well, maybe you can, that's a starting point, but you don't have to prove actual loss. We're just proving that it is reasonable or unreasonable depending on the case. Yeah. Nevertheless, I don't think that the decision itself answer every question that can be raised, you know, and yeah, I guess that's why we have a talk on reform.
Okay, Mr. Oon, I think we need to wrap up the session. Could you do so? And then I would like to move to the next session. Yeah. Sorry to interrupt. I know there are other people who want to make comments, but we will have to defer it to another major forum solely on this matter, maybe.
Thank you. But I think the issue highlighted by Ms. Chung is such that recalls are indeed very necessary.
Mm-hmm.
Thank you, Ms. Chung.
Thank you, Mr. Oon, and especially Nazim too for participating. Yeah.
Well, I want to thank, since the speaker and moderator is still here, I know that there are cumulative, both academic, practical, has been brought to bear with this. This is like an advanced contract law class. For some of us, not yet accessing to this area, today we have been given a tour de force of a panoramic overview of the judicial developments over Section 75 and the contemporary argumentation between even judicial nuances and contestation. As we listen to both the moderator and the presenter, we are thankful. And from New Zealand sharing a bit of his observation and the questions that are posed on the chat, which I will encourage you all to continue to do so. I want to put our gratitude to Kuan Chong Xiaomei for sharing her pedagogical clarity. She teaches remedies in contract law at one time or other in the University Malaya, and we are grateful for her contribution. And Mr. Oon, your singular passion on contract law is demonstrated in the way you introduce the session and also raising questions for Kuan Chung to respond to. With those remarks, I'd like to thank both of you all, and I'd like to now move on to the next session. Thank you very much, Xiaomei and Chiki. Thank you.
Thank you. Thank you for having us.
Thank you. With those remarks, we are now moving to our second session, and we are grateful that today we have Dr. Izura, all right, who teaches contract law, to moderate the session. And we have Dr. Mei Fong, who was once a contract law lecturer herself and the dean of the law school, but now serving in Australia. Together with her is a learned colleague from India. I will now pass the session to Izura to introduce the topic and the speakers. Over to you, Dr. Izura.
Okay, thank you, Prof. Philip. Right, welcome and good evening to everybody right now. So we had a very lively and deep session earlier on LAD Section 75, and it's certainly an area which has become much more muddy due to the cases of cubic and etc. So now we'll perhaps go on to another completely different area, hopefully not as muddy, is dealing with minus contract. And the topic is essentially, it's a very impressive title, which makes me in awe, really. Legal transplantation and judicial interpretation of minus contract. And the question is whether it's protecting or precluding minors. We have today actually 3 speakers, although Associate Professor Sean Starr sends his apologies. He's unable to attend today. So, but we still have our 2 learned and distinguished speakers. Dr. May Fong, Dr. Chong, who was my colleague and former dean. So nice to see you again, May, Dr. May, right? And we also have Assistant Professor Divyangana. I hope I pronounced your name properly, right? Briefly, Dr. May, she's now currently at currently the head of the school at the Thomas More Law School in Australian Catholic University. She's got a whole lot of academic writings with contract. In fact, in my contract class, we're still using Dr. May's textbook. The students love her textbook because it's the easiest and to go through to understand and read, which is very fortunate for me. And we also have Assistant Professor Divyangana. She's a Professor of Legal Practice at Jinda Global Law School, where she teaches contract law, company law, and corporate governance. So we have two extremely learned speakers in contract. And I hand over the floor to both of you.
Thank you very much, Dr. Izura. It's so good to be able to see each other on screen again. And to everybody, a very good evening. On behalf of my co-authors, Assistant Professor Divyangana and Associate Professor Sean Starr, we want to thank you, Professor Philip Cole, and your team for inviting us to this session. To me, it is really enjoyable and I look forward to it because it's back to home grounds. And thank you, Ms. Chung, for a very interesting and, well, as we have seen, a very lively discussion on this. Well, as Dr. Izura has already prophetically thought through, well, this is a totally different area and I hope you will enjoy it as a different discourse, even as we've decided to take on quite a different perspective. And I know there are many practitioners here, but we want to say that minors contracts is still significant. In fact, it is an area which is neglected. And if you think of the fact that the minors, right, I don't think we really think of them in as terms of minors. I see them as very entrepreneurial business person. I see them as people who are very much on the go when with so much potential and business acumen. And that is where the need to review the law is. Because currently, as we know, under Mohari Bibi, there's no valid contract. There's no enforcement of rights by minors, nor people who deal with them. So with that, I would like to share my screen and introduce the topic. I will do the first part and Assistant Professor Divyangana will do the second part. So allow me to do the share screen. All right, can I just inquire, is yes. The screen visible and the right yes. screen? Right, thank you very much.
We can see your file. We do not see a projected.
Oh, I'm so sorry. That means I'm still not getting it right.
Yes. Oops.
Do you see the screen now?
No, it flashed for a while, a purple screen, ACU.
Oh no, it should be a empty screen. I'm so sorry. I share screen.
You can see it. You mean we can't? You can't. We can see it.
Are you seeing the screen?
Yes, we're seeing it.
Yes.
It's transportation. Why you say no?
Sorry, sorry. We're seeing the edit mode of the slides.
Right. Okay.
Yeah, that's fine. Yeah.
Which is fine. Yeah.
Thank you very much, and I am sorry for the miscommunication.
Yeah.
Right. So the title of our paper that we plan to be sending on for publication in due time is Legal Transplantation and Judicial Interpretation of Minors Contracts in India and Malaysia. And that's because of the common heritage that we share from the Indian Contract Act, which by extension, we now see it in the Malaysian Contract Act, 1950. Now we have picked on a very tricky issue. We feel that there's the whole question whether the law currently protects or preclude minors. So this tricky question, protecting or precluding minors. And I start with the outline by first introducing the situation of contracts in Malaysia and India. And then we'll be looking into the issue of Mohari Bibi, which holds that contracts by minors are void ab initio, and to see what are the implications of that landmark decision in 1903. And although it's 1903, it is still a decision that impacts us today. And as mentioned, we would like to see it from the lens of legal transplant of English law and the codification of English law into the Indian Contract Act 1872. And as we have seen from all the various sessions, we are having the challenge that we have a law that is frozen in time. And as lawyers, as academics, we are all interested to see to what extent we can continue to receive developments that are taking places, for instance, in the UK Supreme Court, with so many new developments to keep in times with the business environment. I know Mr. Un in the last session did raise whereby we may be overstepping Section 3, Section 5. And that itself is an important consideration, probably for another conference, about the reception of English law under our Civil Law Act. So these are some of the issues that require attention. And today we do a very narrow field, but important as well, just to look at minors contract. Now we want to introduce this thought about deviations with the transplantation of English law into British India and Malaya at that time. And of course, now, which is still subsisting in our business and commercial laws through the two Contracts Act. To what extent the Indian Contracts Act, through its codification, has deviated from the transplanted law? Or we ask cheekily in a different way, is it the Indian Contracts Act that has formed the deviation? Or is it the decision of the Privy Council in 1903 that actually caused a deviation of the law from English common law? And as we all know, the general position as far as the common law is concerned, as far as minors contract, is that it is voidable. And that provides a very flexible and a very common sense situation to minors contract. So these are some of the questions we want to poke at. And then we will want to critique the decision of Mohari Bibi. And this will be done by Assistant Professor Devgana from here onwards. And she will be looking into detail about the process in which the Privy Council decided that important case, and which has now continued to impact on the laws of both countries. And importantly, what was the aftermath of Mohari Bibi? It has continued to cause uncertainties, and it has caused the Indian courts to look for ways to navigate around that very limiting decision. And finally, we want to look at the way forward. I know this is a very timely conference whereby we look at reforms, and these are some of the things we would like to consider. With that, let me move on to my second slide. Right, I have already did the outline as I have introduced. Now, Philip did mention about capacity, and of course, minors is just one of the issues of capacity, the other being persons of unsound mind, and to a certain extent, the law is rather uncertain as far as drunkenness is concerned. If there are opportunities, we'll be happy to answer questions on those areas as well. In the Indian Contract Act and the Malaysian Contract Act, we notice the word used is competency to contract. And that's where we'll be looking at Section 10 and Section 11. And with that brief introduction, we also see the rationales, the policies, and we want to weigh how far the law has, well, tilted on one side or the other. So generally, there's the overriding protection of minors, and that is a good thing. That is the moral reasoning behind many of these laws because of the fact of their vulnerabilities, their lack of understanding, and there has to be weighed against the interests of persons who deal with minors. As mentioned under the common law, by virtue of that protective interest of minors, contracts are enforceable by minors, but not against the minor. And as far as contracts that have been entered into, then the general effect is that the contracts are voidable, which gives the minor the option to set aside the contract, except of course, for contracts of necessaries, which is a valid contract. Under Section 69 of our Contracts Act in Section 68, an exception which is recognized by the law. So for the purpose of simplicity, we can think of the different areas of situations impacted by looking at some main categories. There'll be some contracts which will be binding on minors. So as we have seen, contracts for necessaries, and that is again looking at the protective function, whereby if this is not made into a valid contract whereby the parties can claim against the property of the minor and all, then there's no opportunity, there's no certainty that minors can obtain basic necessities of life. So that is a good explanation for it. Now, there are also contracts which are binding unless repudiated by minors. These are the general voidable areas. Now, minors can also rectify contracts when they come of age. And of course, some statutes would hold that some contracts by minors are void under certain statutes. Now, today, we only want to look at the position in India and Malaysia vis-a-vis the law in the United Kingdom as far as the common law is concerned. And for simplicity, we have put it as the ICA and the MCA. Section 10 and 11 have the same numberings and of course are in pari material. And as far as Malaysia is concerned, the law in this area has brought about one of the few reforms when we had the case of Government of Malaysia in Gucharan Singh, and because of that, the legislature was amended to bring in the amendment as far as scholarship agreements are concerned. But otherwise, there have not been as many amendments, and that itself reflects on the, well, one will say the perseverance of our statute. On the other hand, the challenges of maneuvering this statute, which is 1872 base. Right, our main focus today is on the Privy Council decision in Mohari Bibi, which was decided in 1903, which held that contracts by minors are void ab initio. And we'd like to have a detailed discussion on this and to see its ramifications and how we should move forward. Right, just a brief introduction to Mohari Bibi before Assistant Professor Divyanna goes into detail. As we have seen, the effect of this decision, which has taken on a totally different starting point from the common law voidable contract, is that effectively there are no contracts which are legally recognizable, which can be formed by minors. Minors do not have the competency to contract under Section 10, which for the sake of everyone, I'll just have a quick read of it. I'm sure many of us would have left this area of law, and there are not that many cases on minors. Section 10(1), all agreements are contracts if they are made by the free consent of parties competent to contract for lawful consideration and with a lawful object, and are not expressly declared to be void. So there's this transition of agreements to contract with the requirements of not only free consent, but also the competency to contract. And that's where the difficulty is when Section 11 provides that every person is competent to contract who is of the age of majority according to the law for which he's subject. And of course, Section 11 deals with unsound mind. Well, I see the difficulty not because of these two sections, but rather the difficulty because the Contracts Act does not go on to expressly provide for the effects of a contract which is entered into by minors. And that was the difficulty that Mohari Bibi tried to resolve and came up with its conclusion that is void ab initio. Now that we see as, well, either a gap in the Indian Contract Act, the Malaysian Contract Act, or I would propose that that was how it was meant to be drafted because of the current law at that time, whereby the common law was premised on a voidable contract. And when we look at the legislative history, the Indian Contracts Act was meant to contain the common law. So I'll discuss that more when we talk about legal transplant and the codification of the English law into the Indian Contracts Act. The other difficulty that would have come about, of course, is that we have minors who are participating actively in e-commerce, in the sharing economy. So if we talk about acquisition of services, provision of services, many minors actually, well, are very entrepreneurial, and that's where the difficulty is, of course, in terms of they themselves are making contracts and buying their own things and all, and of course, goods and services as well. Now, we also have to bear in mind the other interests, which are persons who deal with minors. And when we look at section 64 and 65 of the Indian Contracts Act, the equivalent of section 65 and 66, because the decision of Mohari Bibi held that is void ab initio, minors do not have capacity to enter into contract. And secondly, the Privy Council held that 64 and 65 starts on the premise that it must be by parties who are competent to contract. So there are no remedies available if the parties are, in the first place, not persons under 64, which the court has interpreted as persons who are first competent to contract. So we have the difficulty of remedies as well, as to how we should address situations whereby remedies are required. And as mentioned, we'll then go into the issue of precluding. Well, we humbly submit that Mohari Bibi was wrongly decided, and that the 4 aspects in which the Privy Council relied on for the decision was not sufficient to justify the conclusion that they have come into. Well, the other secondary submission would be that Mohari Bibi should be confined to its own facts. And when we look at the facts of Mohari Bibi, it is a case whereby it is an enforcement of a mortgage against a minor. The unfortunate trend, however, has been that the courts, whether in India or in Malaysia, have actually applied the principle of Mohari Bibi to all contracts, as we have seen to Gucharan Singh scholarship agreements and to contracts which are in favor of minors. So when we have the discussion of 2 cases, Matai and Rachava's case, those were in fact mortgages which are in favor of the minors. But because of the basic proposition which has been applied to all contracts in Mohari Bibi, the court in those cases held that those were contracts which are void ab initio itself. So this is where the law needs to be reviewed. This is where the law does not seem to serve the justice of protecting minors. So we want to query whether the law, although intended to protect minors, has ended up precluding minors and the way forward. I come now to the part on legal transplant, and I think this brings us a bit of a history, which is useful for any contract teachers, contract lawyers, contract students. So the idea of legal transplant, of course, has been first coined by Alan Watson, and of course some authors suggest that that there were also competing academics who were already bring up those thoughts at that time, but the the official origin of this whole concept is to Alan Robson. And this is where there's an adoption of legal rules and concepts into the national system of one country, we call it the destination country, from its original source found in another country. And Watson actually takes the view that there can be a transplant without the need to have differences in legal systems, social political environments and all. The laws can easily be transplanted from one origin to the destination. And in many ways, we see that happening in a way the legal history and the laws in India and Malaysia has developed. And of course, there's a lot of colonial laws, a lot of imperial laws at that time. And this brings us back to the history of the trading ties administration by the East India Company. And with that, there was a need for administration, a need for certainty in the law, whether to British India or to the trade settlements. And in relation to the trade settlements, we can see the developments from 1826, and of course, later becoming a crown colony in 1867. I like the description that I see in the textbooks on Indian law, whereby in the larger towns, the presidency towns of Madras, Calcutta, and Bombay, they were already governed by very sophisticated courts. They call them the presidency towns. And this courts, most of them, of course, having judges who were from England at that time, were already using laws, British laws and all. So in many ways, the trading ties, the environment at that time already brought in a transplant of English law. So there was a clear transplant in that sense. Now, the difficulty was in the smaller towns, what was known as the mufasils, whereby the judges were given much more freedom, because the administration didn't move on to so many towns, and there was a need to depend on the local judges as well and all. So the decisions were based on general principles of justice, equity, and good conscience. And that's where there were uncertainties, there were changes in some of the laws and all. So with that came the codification and the aim for certainty, the guidance to judges to decide cases. Now, I'm sure many of us are familiar with the drafting of the Indian Contract Act, 1872, eventually completed by the Third Law Commission. That is interesting because from here we can see that it was not only English law that was transplanted, because by the second revision, there was a lot of borrowing. And I think for those of us in contract, we will have remembered Section 17 on fraud. We always say that it was, from the New York Code of Civil Procedure, and how did it come from such a different form of jurisprudence. And in fact, besides this, there was also the transplantation of Roman law in the Italian codes as well. Now, of course, the final revision was by Sir James Fitzgerald, who was very much recognized for this, and finalizing the versions and adding introductory definitions. Now, we just want to invite this thought. With this mixed legal system, effectively, there's what we call deviations in the law. So did the Indian Contracts Act cause a deviation from English law, right? So that is something I do not really subscribe to, because by and large, from the draft bill that was intended, which was first draft, to the final revision, much of English law, in fact, remained intact and was actually brought in. Now, we want to suggest that Mohari Bibi form another of the deviation, and that's where the discussion of Mohari Bibi will become interesting as we try to look at Mohari Bibi. So with this, I'll pass the time to Assistant Professor Divgana to bring us to an analysis of Mohari Bibi and a critique of it. Over to you, Div.
Thank you, Dr. May, for an insightful introduction on the topic. It was very clear and very well presented. I'm grateful to the University of Malaya for inviting me for this wonderful webinar on a very crucial but seldom discussed topic. My presentation is divided into 3 parts. First, an analysis of Mohari Bibi. Second, the impact of Mohari Bibi on other decisions and on the protection and preclusion of minors. And lastly, suggestions for reform. When it comes to the analysis of Mohari Bibi, the first observation we make is that the appeal to the Privy Council was made essentially on 2 points of law. First, whether estoppel applied to minors, and second, whether Section 64 of the Indian Contract Act 1872, or the ICA for short, applied to minors. And Section 64 is analogous to Section 65 of Malaysia's Contract Act 1950. And this is a provision of relief under voidable contracts. And it essentially says that if a benefit was received by a person at whose option that particular contract is rendered voidable, then that particular benefit needs to be restored to the other party upon rescission of the contract. As such, if English law was really followed in toto, then if a minor's contract was held to be voidable, then the minor would have to return any benefit under the contract. Now, how does this apply to Mohari Bibi? In Mohari Bibi, the lower courts presumed, and that's the important part, that there was a presumption that minors' contracts was voidable and aligned with English law of the time. Therefore, the question to be answered was whether the minor should restore a benefit, which was the advance money received under a mortgage contract, back to the moneylender. Now, in the High Court of Calcutta, which is one step below the Privy Council, it was held that Section 64, which is the provision of relief in relation to voidable contracts, that did not apply to minors. And it applied only to those who were competent to contract. As such, relief could not be granted to minors' contracts. So there was no distinction between voidable contracts with respect to adults and minors in English law at that point in time. And so most likely thinking about this particular question of law on the availability of relief under Section 64 as being unsettled with respect to minors' contracts, perhaps the moneylender appealed to the Privy Council to decide this particular question of law on whether Section 64 of the Indian Contract Act applied to minors. And this brings us to a key observation that the question on whether contracts with minors was void or voidable was not a question before the Privy Council at the outset. At the outset, what the Privy Council had to decide was whether Section 64 on relief was applicable to minors. All right, now to answer a question of relief, the Privy Council had to go a few steps back. So in essence, it was saying, hold on, you've come to us with a question of relief, but first let us look at the stage of contract formation to discern the type of contract that is formed by minors, if at all. So let's not rush, let's not talk about relief first, let's look at contract formation. And that's when the Privy Council, it asked the parties to re-argue on whether contracts with minors was void or voidable. And what we also saw was that after considering some select provisions of the ICA, the Privy Council noted that contracts with minors did not exist at all. So after the re-argument happened, and we don't really know what both sides had argued because that did not form a part of the decision. All we know is that the Privy Council considered some select provisions of the ICA to note that contracts did not exist at all. Therefore, this question of whether Section 64, or which is applicable to voidable contracts under the ICA, or Section 65 that related to void contracts, which is analogous to Section 66 of Malaysia's Contract Act of 1950, that did not arise at all with respect to minors because the contracts only didn't exist. So if there's no contract formation, you can't go to the next step of relief. That's the first point that we note. Now, the second point that we note was that Mohari Bibi was a deviation from the general current of decisions from the lower courts that had by and large held that contracts with minors were voidable. Now, these cases categorically held that in India and England, the law was the same with respect to minors' contracts, in the sense that in England, if they were voidable, then in India also contracts with minors were meant to be voidable under the ICA. So not just under common law, but even under the ICA, they were meant to be voidable. That's what the lower courts said. However, the high courts later on in time, before the Privy Council's decision in Mohari Bibi, they began to speculate whether the true interpretation of the ICA was meant to hold minors' contracts as being voidable. So, for example, in a case on specific performance, the High Court of Calcutta, as a passing reference, because remember, this was a case of specific performance, and as a passing reference, what the High Court of Calcutta did was it declared that Section 11 of the ICA, which dealt with competence to contract, that made it apparent that minors were not competent to contract. And this ipso facto led to the conclusion that minors cannot contract at all, in the sense that contracts only don't exist. So it's a very simplistic reading, in our humble opinion, of Section 11. That the High Court at that point in time declared that there could be no further interpretation of Section 11, but just that minors are not competent to contract. However, let us not forget that this observation on void or voidable nature of contracts was made as a passing reference in this particular decision of the High Court, because the real question was whether specific performance could be a relief that was granted to the other party or not. So as such, if you look at what the law before the High Courts was, before Mohari Bibi, the law remained that contracts with minors was voidable and not void. So that's our second observation. Now, the third observation that we note was with respect to the Privy Council taking its discretion as the highest court of appeal to what we think as the extreme. Now, they clearly state in their judgment that we will not be relying on any cases on voidable or void contracts. Rather, they stated, and I quote, "Their lordships consider themselves at liberty to act on their own view," indicating they were going to be starting with a fresh slate and interpret the ICA as they thought it should be interpreted without considering any case or even the legislative history of the provision that they were so keen to interpret. So if we have lawyers and professors of statutory interpretation amongst us, we have only but to ask, and they will inform us how precarious it is for a statute to be interpreted without adopting the appropriate and well-defined tools of interpretation. This is something that we find fairly troublesome in Mohari Bibi, where we can't really identify these well-defined tools of interpretation being utilized to interpret the various provisions of the ICA, which led the Privy Council to conclude that contracts with minors did not exist. The fourth observation that we made is with respect to the method by which the statute has been analyzed. The Privy Council quotes Section 10 and 11 as it is. And instead of engaging in some form of a cogent or comprehensive reasoning, it simply summarizes its interpretation of these provisions in 2 or 3 lines, stating parties need to be competent to contract, number one, and minors are not competent to contract. And yes, this is true that parties need to be competent to contract and minors are not competent to contract, because that is what English law also says. It's the same thing that they say, that minors do not have competence to contract. But let's hold on a minute and ask ourselves, how does this lead to a conclusion that minors' contracts are void ab initio? It doesn't. All I'm saying is that minors are not competent to contract. How does that lead to a conclusion about the nature of their contract? For if that was the case, under English law, minors' contracts should also be void ab initio instead of voidable, because like English law, like the ICA, sorry, English law says that minors lack the competence or capacity to contract. So this seems to be the concern with Mohari Bibi, that it has extended an idea which the ICA was silent about. Nowhere in the Indian Contract Act does it explicitly state that contracts with minors are void ab initio, or they don't exist at all. And neither was the ICA providing an answer on this particular issue of void or voidable nature of contracts to be any different from English law. And that in essence is the crux of our paper, that there is nothing really from the ICA that sort of informs the reader that the ICA was meant to have an interpretation different from English law. The other provisions Mohari Bibi considered as a part of statutory interpretation to answer this question on void or voidable nature of minors' contracts was Section 68 of the ICA on supply of necessaries, or the necessity exception, which also existed under English law. However, the Privy Council was observed to mince its words by saying even for necessaries, and the emphasis is on this word even for necessaries. Minors are not liable personally liable for those necessaries. Their property can be charged, but they can't be personally made liable. And they were trying to cement this point on the non-existence of the contract by remarking on the extent to which minors are protected in India. That they're trying to say that, the protection is so strong in India that, even for necessaries, minors cannot be made personally liable, which again is a problem. This is because minors were not personally liable to pay for necessaries under both English law as well as under the ICA. Therefore, on this particular point, there was no difference in both jurisdictions. That's between English law and the ICA, that the Privy Council was trying to carve out on the lack of personal liability of minors with respect to necessaries. Now, the Privy Council then relied on four other provisions on the law of agency and partnership with respect to minors. What we find in our investigation is that the interpretation adopted by the Privy Council was quite different from the interpretation followed by leading commentators at that point in time. And therefore, after answering this question on minors' contracts do not exist at all, and later on, the term that was popularized to describe this situation was void ab initio. That is, minors' contracts are void from the start. So after this, the Privy Council moved to the next step. So first step, they've clearly said contracts don't exist. And so the next step, as far as relief is concerned, with respect to Section 64 of the ICA, that we know is analogous to Section 65 of Malaysia's Contract Act 1950, and Section 65, which is on void contracts, which is, I think, analogous to Section 66 of Malaysia's Contract Act, and that's basically for relief under void or voidable contracts. That doesn't apply to minors, because if you're not meeting the first step of contract formation, relief doesn't the question of relief doesn't arise. So this seems to indicate that the courts were exceedingly protective of minors, and in their bid to protect minors, the Privy Council declared contracts did not exist, and therefore all questions around contractual liability on both sides, with respect to the minor as well as with respect to the other party contracting with the minor, that should cease to be asked. I now invite Professor May to discuss the two Malaysian cases of Leha Binte Juso and Tan Hee Juan on the impact of Mohari Bibi on these two Malaysian decisions and whether they have deviated from Indian law on relief or remedies. And then, of course, thereafter, we can look at preclusion and protection of minors.
Right. Thanks, Div. That was very helpful to go into the details of Mohari Bibi, and the Malaysian courts have followed Mohari Bibi as far as the first principle is concerned, that minors contract are void ab initio. However, interestingly, in Leha Binti Juso and Johari bin Hashim, decision in 1978 by the Federal Court, the Federal Court did not refer to the second aspect of Mohari Bibi in relation to Section 65 of our Malaysian Contract Act. And in that case, the court moved on to Section 66 as well, and actually allowed a remedy, even though in that case, the minor was the person seeking the remedy was actually the minor. So in this case, the court actually ordered the seller to return the deposit to the purchaser who's a minor. I find this interesting to the extent in which the court dwell on the protective nature of the law protecting minors. Another good example is the case of Tan Hee Juan and Tan Boon Kiat, a very much earlier case in 1934, which dealt with the Specific Relief Act, Section 41, whereby a person who is asking for the cancellation of a document, the court has the discretion to order the person to compensate the other party as justice required. And again, in this case, the seller was a minor, and in cancelling the document because of the lack of competency, the court did not order compensation on the ground that the discretion is only to be exercised if the parties were in a fiduciary relationship, and the parties in this case were not in a fiduciary relationship. I quote the statement by the court, whereby the court said that it was a harsh decision to the defendants. However, it is my duty to protect the interests of the infant while he's an infant, as the law provides to protect the property even against his will. And of course, in that particular case, the infant actually stated he did not want the property to be protected. So we just want to use this as illustrations of the intended protection for minors. And I think in the next part, when we talk about preclusion, Div will be discussing about how two cases in India showed the ramifications from the decision in Mohari Bibi. Back to you, Div.
Now, to understand the effect of protecting or precluding minors, we consider the case of Matai and Raghavacharya. Now, we start by considering the case of Raghavacharya because it was decided earlier in time and it was a decision of the High Court, which is one step below the apex court of the country, which is Supreme Court. Now, it was one of those cases that set forth a string of decisions where minors' contracts could not be enforced. So it followed Mohari Bibi to that extent. And minors' contracts continued to remain void ab initio. But the transfer or conveyance of a property could be made to a minor. As such, what this case did was distinguish between contracts on one hand and transfer of property on the other. Now, what aided this interpretation was the fact that contracts and transfers were governed by two separate legislations in India. The first is the Transfer of Property Act 1882, which governed transfer or conveyance of property. And the second was the Indian Contract Act of 1872, which governed contracts. So what we start by asking a fundamental question is, can a minor receive property under a transfer regardless of contract? The answer is yes. Parents may decide to transfer property to a minor as a gift or gratuitously. And children may receive birthday presents, and they do receive birthday presents all the time. And these are classic examples of transfer of property where a toy or a book is handed to a child. Now that we've entered this domain of transfers, the question is, should a plea that a minor is incompetent to contract be the basis of not enforcing a transfer? And we're not speaking about contracts here, but of transfers. So the answer should likely be no. The contract should not have an effect on whether property is transferred to a minor, because if incompetence is the basis of holding that a minor can never be a part of a transfer, the minor will never be able to receive property at all, because all transfers by virtue of the contract should then be void ab initio. Right? So that becomes a bit of a troublesome conclusion. And this may not be what the Transfer of Property Act intended. Accordingly, the High Court in Raghava held that if a transfer, firstly, is for the benefit of the minor, and second, the minor is receiving property and not giving it away, the transfer should be valid. Now, the transfer is not colored by the contract. So what the High Court is saying is that look at both separately. Look at transfer separately and look at contracts separately. As such, regardless of what the contract says, if under a mortgage or sale of property, a minor is receiving the property as a transferee and not a transferor, the transfer is permitted and the court will uphold it. So this distinction between transfers and contracts allowed minors to receive property under a mortgage or any other type of conveyance. Therefore, transfer of property was a method by which the law came to the aid of minors and included them in general transactional activities, and at the same time protected them from the unintended consequences of contracts, because they're saying, we're not looking at your contract, don't even show it to us. We are looking at your transfer, and we want to know whether this transfer can be made to a minor, whether you have a contract or not, we don't want to look at. So let us understand this distinction between contracts and transfers a little bit better, because that will help us understand whether minors have truly been protected or have they truly been precluded from transactional activities or from society in general in that sense. So a minor takes money from a parent, goes to a shop to purchase chocolates. Now, we know the contract between the minor and the shopkeeper is void ab initio. Now, what does that mean? That simply means neither party or neither person has a claim against the other in the court of law. That is, this particular contract will not be enforced. So let us say that the minor asks for the chocolate, the shopkeeper hands over the chocolate, and the minor refuses to pay. Now, the other party cannot go to the court of law to claim enforcement of the contract. A quasi-contractual remedy is available. That's as far as contract is concerned. However, this is different from saying the transfer is void ab initio or is invalid, because this means the act of handing over the chocolate itself, whether for money or anything else, that should not be undertaken.
Dave,
at this point, yes.
Yep. Maybe we may need to go to Matai and Matai so that we have a bit more time for questioning. I'm aware of the time running up. Thanks.
Sure. Okay, all right, almost done. So we know that as far as transfer is concerned, that this particular point was considered by the court in Raghavacharya, where one of the judges claimed that if minors could not make transfers, they would not even be able to purchase a packet of sweets, because the very act of handing over the sweets would then be perhaps invalid. So accordingly, the court in Raghava allowed the transfer of property under a mortgage without enforcing the contract. However, fast forwarding to 2014, in the second decision on the matter of void and voidable nature of contracts, which is Mathai, a judgment from the highest court of India, so that sort of supersedes Raghava, even a beneficial transfer under a mortgage could not be made in the favor of a minor. So in this particular case, a mortgage had been made in a favor of the minor for a sum of money. Now the sum advanced was for the minor's benefit. The Supreme Court relied on Mohari Bibi to reiterate that minors' contracts do not exist. So they've taken the same approach as Mohari Bibi and they've reiterated whatever Mohari Bibi has to say, but they've gone a step ahead and held that minors could not even make a transfer, whether as a mortgagee or as a mortgager, and whether it's for his benefit or not. As such, minors were completely precluded from commercial realities whereby they could not even make transfers with respect to their mortgage. So this stringency in holding minors' contracts void ab initio, in effect, turned a more liberal interpretation on transfers in Raghava to a more stringent approach in Mathai that affected them legally even beyond the sphere of contract law. As such, there is scope for reform, and there are two possibilities that can exist. So that's the suggestions of reform, the last part of my presentation. First, a judicial reinterpretation, and second, a legislative amendment of the ICA to include another provision to specifically declare what exactly will be the nature of the minor's contract. However, we find ourselves leaning towards judicial reinterpretation because minors' contracts are affected by different aspects, whether the contract is binding unless ratified or whether there are non-binding contracts. There are also issues of situations within which the contracts can be enforced, and of course, the nature of the contract itself, whether void or voidable, depending on the situation at hand. So just having like a simplistic provision on the nature of minors' contracts may not be the solution to really appreciate the various nature of minors' contracts. Therefore, it will be easier for a judicial reinterpretation where judges will have time and space in the judgment to consider situations and reasons on where and how minors' contracts can be void or voidable. With this, of course, I end my section of the presentation and invite Professor May to share her thoughts on the last section.
Right, thanks, Dave. I just want to add a bit about the Australian position. One other possibility, of course, is to have comprehensive legislation dealing with just minors' contract. And in Australia, different states have different models. So most states have taken the model whereby the statutes complement the common law. But at this point of time, it's interesting to just consider the New South Wales Minors Property and Contracts Act 1970. So this is the most comprehensive legislation, and in fact, it abolishes all common law rules and introduces the concept of a civil act, which includes any act relating to contractual or proprietary rights or obligation or any chosen action. So it is very comprehensive and provides for contracts which are presumptively binding on minors. It provides for situations for minors to affirm or to repudiate a civil act. So it has been considered to be the best for minors, as in taking care of all the needs and situations of minors. So with this, we end our presentation and we'll be very happy to take on any questions. So back to you, Dr. Izura.
Okay, thank you, Dr. May and Dr. Diwan. I will have to say that minors topic, what both of you have presented, has certainly created a lot of thinking on this part, especially with regards to the revelation on the concept of Mohari Bibi and what the legal transplantation and how it had actually deviated from its normal aspects. It is true that now we have a lot of minors who are active and even millionaires at 13 and 14 just by becoming a YouTuber. They can become a millionaire, and it seems ridiculous that they can't be held accountable for any contracts. So the simplistic view of saying Mohari Bibi becoming void ab initio would not answer this situation. So if I appreciate the fact that the concept that we're actually supposed to protect minors should be the primary aspect, but that does not translate to the contract actually being void ab initio. It is much better to actually look at the situation, like you have both rightly pointed out, depending on the situation, it can be void, it can be voidable. But how you can actually reach this would need an understanding of not using Mohari Bibi blindly by just saying it's completely void ab initio, and understand its concept. So it's a very interesting points that you have raised. And I see from the chat there are a lot of questions from Philip actually that he raises a few points. For example, one of it which Prof. Philip acclimates, he says that he's agreeing and that Section 10 has a lot of scrutiny and significance with the lens of capacity. But the issue is whether or not they have received a benefit, or can minor have any remedy, or is it precluded even since it is void ab initio? Do you have any thoughts on this?
Well, thanks, Professor Philip, for this interesting question. We were looking at the point of the fact that by virtue of the general proposition in Mohari Bibi, minors are precluded from the very beginning itself, in the sense that they don't have enforceable rights and all. And in terms of whether they have received benefits and all, then the cases have shown that well, the courts have been protective, and where the sections have allowed it, the courts have actually allowed the minors to actually retain the benefits, whereby it doesn't come within the provisions of the Act for the return of it, which we have tried to show from 2 cases. Right. Your second question is regarding web contracts on taxi hailings and all. The attentions of minors who have downloaded music and all. So in fact, these are the areas that we feel the law currently doesn't sufficiently provide for it. And the way I understand it, business probably absorb it rather than, you know, to raise litigation on this issue. So as Dr. Izura has mentioned, I mean, with the different entrepreneurial, different type of minors that we see, we believe that the time should come whereby these issues are addressed in a legal manner, and whereby reforms should be considered and all. Your third question is passing of title in property, and in relation to the UK Contract Act 1987. So this is where the issue of law reform and the reception comes in. By virtue of our Section 3 and 5, I think there will be difficulties trying to utilize some of these provisions. And this is where I think there's a need for us to address this issue by way of reforms as far as Malaysia is concerned. And we felt that the issue of reforms are important by virtue of the fact that as we could see, Mata and Mata actually went one step backwards from Rachava's case. So in the case of transfers, where Rachava allowed it, Mata has now gone backwards. And so these are therefore pressing issues, not only for India, but also for both jurisdictions generally. Div, would you have anything to add to that?
Yes, in terms of reform, I think that there is still scope in case there is another issue that comes up with respect to minors contracts before the Supreme Court of India, to really reconsider not just Mohari Bibi in terms of statutory interpretation, but also with respect to transfers. Because if you look at why Raghava did what it did, was because number one, the minor was really losing out on a benefit. And the minor had already paid the money with respect of the property. And the minor would have somewhere been at the losing end, which the courts did not want. And that's why they had to rely on the Transfer of Property Act to provide some sort of a relief to the minor. So instead of actually going through this very complicated, method of distinguishing between contracts and transfers, as long as you recognize minors' contracts as voidable, you're providing a balanced approach. You're providing the minor with protection with respect to their contracts by saying that, look, the contract cannot be enforced against the minor. Further, if the contract is detrimental, that will anyways which be void. That's detrimental to the minor. However, where the contract is beneficial to the minor, there is still scope to enforce that particular contract. So voidable contracts provide the balance, not just of protecting the minor, but also with respect to providing some scope of relief to the other party. So rather than at the first step, taking this very staunch approach of saying, no, we're not even going to consider contracts with minors in existence, you're saying, yes, the contracts exist, but we will enforce it only in certain types of circumstances. And this allows the other party at least some sort of, an understanding that, look, we still have scope of relief at a later stage because the contract itself is being recognized.
Okay, thank you very much, Prof. Diana. It's certainly, I mean, I'm really keen on the concept that is voidable because for the reasons they've stated, it actually addresses the problem with regards to minor. And my personal opinion is we have got so many conflicting decisions, like Leha's case. The decision was for the benefit of the minor, but it gave a very sour taste in the mouth because it could not explain why could Section 66 of the Malaysian Contract Act be used when the minor is void ab initio, whereas and the case never went on to explain what was how it could be applied. I mean, it was a nice result, but raised too many questions. But if it was voidable, then it would not be a problem. Section 66 can be used easily. It will protect the minor at the same time. Due to lack of time, I'll just have to quickly choose one or two questions. But I think that what was said, even with Dr. Ong's question, and we have Amara's question, which is, I believe it's basically answered already through other means from the talk. We do have, sorry, Mr. Abdul Majid, you raised your hand earlier and you put it down. Would you like to ask? There will be the final question. Except for the writing, that one, I'll leave that to Prof. Philip to answer, whether or not it's going to be published. But yes, Mr. Sorry, or Dr.
Majid. Yeah.
Yes.
Okay. I'm going to go off slightly, but I hope not too much from what Professor May said. If I understood you correctly, you said in the presidency towns, you had sophisticated judges, but in the smaller towns, the judges had much more freedom. They concentrated on justice, equity, and the like. Now, did equity feature in any big way in this matter? Because equity has been brought up, but I don't see it anywhere. Did the courts ever look at equity, or did the Indian courts not consider equity?
I think this would be a good time to introduce about Turnstone and the Infants Relief Act that the Privy Council also referred to. So to you, Div.
So equity was definitely considered. What the Privy Council said, it relied on a case from English law, which is Norman Thurston, something to that effect, which was based on the Infants Relief Act of 1874. And what was novel about this particular, it was a UK-based legislation, which had simply a persuasive value in India. It was not binding on India at that point in time. And what this particular legislation did, which currently is repealed in the UK, was that when it came to contracts with respect to any money that's been exchanged between the minor and another party, then that particular contract was considered void. So rather than the common law principle of holding contracts voidable, this particular legislation made certain types of contracts with respect to lending of money or property with respect to minors as void. And they said that restitution did not apply, and equity in that sense could not come to the rescue of such a person in a mortgage or a lending transaction. And therefore, what the Privy Council did was they extended this particular Infants Relief Act of 1874 to India, saying that because this is a void contract, equity cannot come and assist the other party.
Yep. Okay, thank you.
All right, and thank you very much to our speakers, Prof. May and Prof. Div. I'm sorry, I have to shorten your name, it's easier. And thank you for all the, and Ms. Chong as well for the earlier speech, where we've, all of us, I believe, have certainly left a lot to think about, has really expanded on our normal thinking, what we used to view certain subjects. So I hand it back over to you, Prof. Philip.
Thank you, Dr. Izura. Thank you for your able chairing. Assistant Professor Divyangana and Dr. Mei Cheong, this wonderful lecture. I first, when the topic was suggested, I thought, isn't it rather narrow? And why should anyone be interested? That's why in my comment, I said, it is a lens of which we see the tension on legal transplantation and the historical backdrop of how the law has developed in contemporary society. Thinking out loud, our attempt in this series of webinar is an attempt to interrogate questions and to raise issues stretching the horizons of juristic reasoning and interacting and interfacing with judicial decisions and private practitioners. Undoubtedly, for infant contracts, the only thing that went to reform in Malaysia is the scholarship, because the public sector was involved in public money. It is not an area much thought has been given to. But nonetheless, this afternoon, late afternoon discussion, and Professor Div especially giving us the Indian experience, has shown to us that there are many issues that even besets this area. Thinking out loud, I can imagine that the whole issue of capacity, not just for infants, thinking out loud, I look at Companies Act. Companies have unlimited capacity, all right? Then you have issues on judicial review and challenge, government contracts, where government regime change terminate contracts. Then you have sovereign immunity, issues of royalty, giving concessions through state-owned or GLCs or state excos. There are complex issues governing capacity. And even though minor contract seems minor, it has shown to us that these issues are all pervasive. Your sharing unselfishly this afternoon has stimulated thought. And I thank Professor Div and Mei Cheong. I hope that this relationship we have set up in these conversations would continue. And in the event we have initiative to actually reform the Malaysian Contract Act, I do welcome the participation of Indian institutions or South Asian jurists like yourself. I don't know whether we have any budget to pay anybody. Let me see whether we can lobby the government, which currently has the alumni of Universiti Malaya everywhere, including the Prime Minister and the Attorney General and the Minister of Law, whether we will make any headway on this reform of private law, which is not a sexy subject for any government, all right? I don't know. We travel in hope. The work of jurists like yourself, unselfishly tilling the ground, archaeological retrieval of the history, the interpretive horizons, these are really provocative and fertile ground. I want to thank everyone, Dr. Zura, for chairing, and all those in the background, and all of you who have continued to listen to this. I can see 72 participants still sign on, and the Facebook streaming. Raymond, how many hits are there in the Facebook streaming? Do you know?
I wasn't paying attention the whole time, but right now there's only 6 left.
Okay.
7. Yeah.
All right. Next time, do keep a view, because it's nice. I mean, it's good to see. And in any event, I want to wrap this up. It's already 6:10. I've borrowed more time than I should from all your lives. And I greet you all and thank you all for your contribution. With permission, of course, could we send out your slides to all the participants? Of course, participants, take note, these are in some way copyright. Please don't purloin it or plagiarize it without acknowledgement. And they're not for actual citation anyway. They are just provisional thoughts from the 2 jurists which are shared unselfishly with us. Thank you for everyone who has posed questions. Apologies if we are not able to interact directly with all. I bid you good night and salam and good evening to everyone. Thank you.
Thank you.